The question was 4 words. Simple. Factual. The kind of question a first grader could answer. The kind of question that has one correct answer, documented in official federal records, certified by Congress, and verified by every court that reviewed every challenge brought against the result. 4 words. Who won the 2020 election? Kara Westerkamp could not answer it. Not because she didn't know, not because the answer was unclear, not because the question was ambiguous or complex or constitutionally sensitive. She could not answer it because she had been told not to. Because someone, somewhere in the preparation process for this confirmation hearing, had decided that the safest answer to a factual question about a presidential election was not the fact. It was a recitation of constitutional procedure. And Westerkamp, a nominee for a lifetime appointment to the federal judiciary, a position that requires, above all else, the ability to apply facts to law, sat in that chair and delivered the recitation. Perfectly, mechanically, word for word, as though she were reading from a card she had memorized the night before. Because she was. Richard Blumenthal has been in enough of these rooms to recognize a rehearsed non-answer. He served as Attorney General of Connecticut for 20 years before coming to the Senate. He has questioned witnesses who did not want to answer. He has sat across from people trained in the art of saying a great deal while committing to nothing. He knows what it looks like. And he knows that the most effective response to a prepared evasion is not a longer question. It is a shorter one. Miss Westerkamp, who won the 2020 election? Westerkamp's response came with the smooth, practiced cadence of someone who had delivered it before. Senator, under our Constitution, the Electoral College votes for the president, and that is certified by Congress. And in 2020, President Biden was certified by the Blumenthal stopped her. Yeah, that's not my question. Who won the election? Again, Senator, under our Constitution, Blumenthal cut through it again. He was not interested in the Constitution. He was not asking about the mechanism. He was asking about the result. And Westerkamp's refusal to separate the two, her insistence on answering the question of how a president is chosen instead of who was chosen, was itself the answer. Because a person who has no reservation about the 2020 result can say, Biden won. 3 syllables. No constitutional scaffolding required. The scaffolding only becomes necessary when the answer itself is the problem. Blumenthal pressed harder. He put something on the record that changed the weight of everything that followed. He referenced a tweet Westerkamp had posted on January 6, 2021. A tweet in which she had written, in reference to the 2020 election results, that a certified lie is still a lie. He read it back to her, not aggressively, precisely, because precision was the point. A certified lie is still a lie. Those were her words, posted on the day the United States Capitol was attacked by people who believed the 2020 election had been stolen. And now she was sitting in front of the Senate Judiciary Committee, being considered for a lifetime appointment to the federal bench, refusing to say who won that election while citing the certification process as her answer. The contradiction was not subtle. A certification she had publicly called a lie was now the only answer she was willing to give to a question about its result. Blumenthal named it directly. I know who was certified, and I know what you think of certification. And then he asked again, who won the 2020 election? Let me make it more specific. Who won the popular vote? Again, Senator, under our Constitution, what matters is who the Electoral College votes. Blumenthal stopped her. I'm not asking you for what the Constitution says. I'm asking you for your view, factually. And then he said something that cut through every layer of the prepared answer, every rehearsed deflection, every constitutional citation Westerkamp had arrived with. Frankly, we've received this kind of canned, ridiculous answer before, as you know, because you were instructed to give this answer, right? The room understood what Blumenthal had just done. He had not accused her of lying. He had accused her of not thinking, of sitting in a chair reserved for an independent legal mind and delivering talking points prepared by people whose interests were not the law's interests. And he had done it calmly, without theater. The way a prosecutor names a pattern not to embarrass the witness, but to make the pattern visible to everyone watching. Westerkamp said she was speaking to what the Constitution provided under Article 2. Blumenthal moved on. Let me ask you something else. Who won the 2024 election? And this time, Westerkamp answered immediately. In 2024, the Electoral College voted for President Trump, and Congress certified President Trump as the winner. No scaffolding, no delay, no careful recitation of constitutional mechanisms. Just the answer. Direct, immediate, clear. Blumenthal let that land. He did not need to say what everyone in the room had just witnessed. The same question, applied to two different elections, had produced two entirely different kinds of answers. One election got constitutional procedure, the other got a name. And the only difference between those two elections, the only relevant difference, the one that explained why one required a framework and the other required only a word, was which candidate had won. Then he shifted. Was the United States Capitol attacked on January 6, 2021? Westerkamp said she condemned all of the violence that occurred on January 6th. Blumenthal looked at her. We're not going to get an answer from you. He moved on. But the January 6th question was not a digression. It was the same question wearing different clothes. Because the two facts are inseparable. Who won the 2020 election and was the Capitol attacked on January 6th are not independent historical questions. They are two halves of the same event. The attack happened because of a claim, a specific, documented, repeatedly adjudicated and rejected claim that the election had been stolen. A nominee who cannot say Biden won the 2020 election and cannot say the Capitol was attacked is not expressing caution about two separate issues. They are protecting one single narrative, the narrative that justified January 6th. And a federal judge who cannot bring themselves to contradict that narrative, who sits in front of the Senate Judiciary Committee and treats documented historical reality as a matter of ongoing debate, is a federal judge whose rulings in any case touching elections, voting rights, or political accountability will arrive carrying the weight of that evasion. Not as bias anyone can prove, as a posture everyone can see. It was a system. A coordinated, pre-rehearsed system of non-answers designed to get judicial nominees through confirmation hearings without committing to any statement of fact that might create distance between themselves and the political movement that nominated them. The answers were identical across nominees. The phrasing was identical. The constitutional citations were identical. Witnesses who had never met each other, preparing in separate rooms with separate advisors, arriving at the same hearing and delivering the same words in the same order. That is not coincidence. That is instruction. And instruction is the problem. Because the federal judiciary is not supposed to be instructed, federal judges are supposed to be independent. That independence is not a procedural nicety. It is the structural guarantee that the law will be applied the same way regardless of who appointed the judge applying it. When nominees arrive at confirmation hearings with rehearsed answers to factual questions, answers designed not to inform but to protect, they are demonstrating, before they have been confirmed, that their independence is already compromised, that someone else's interests have already shaped what they will and will not say, that the lifetime appointment they are seeking will not be exercised in the service of the law alone. Blumenthal said it directly, without softening it. The answers here are obviously canned, pre-rehearsed, Orwellian in their denial of reality. And they are a subversion of this process. They're an insult to this committee. But they also fundamentally show a complete lack of independence and backbone and impartiality, which are the fundamental requirements of a United States District Court judge. Independence, backbone, impartiality. 3 words, each one a requirement, each one absent from every answer Westerkamp had given. Not because she lacked intelligence, not because the questions were difficult, because she had decided, or been told, that the safest path through this hearing was to say as little as possible that was true, to answer every factual question with a procedural framework, to treat reality as though it were a matter of constitutional interpretation rather than documented historical record. The 2020 election has a winner. That winner is in every official federal document produced in its aftermath. It was certified by Congress. It was upheld by more than 60 courts. It was confirmed by election officials in every contested state, including officials appointed by the opposing party. It is not a matter of debate among people operating in good faith. It is a fact. In a nominee for the federal judiciary, someone who will be asked, if confirmed, to apply facts to law in cases that affect real people's lives, who cannot say that fact out loud in a Senate confirmation hearing, is telling the committee something important. Not about the election, about themselves. Blumenthal's final observation was not a question. It was a verdict. He told Westerkamp directly that he was disappointed she was not more original, that she couldn't find a few different words, that he was amazed. The amazement was not performative. It was the specific, exhausted amazement of someone who has watched the same scene play out enough times to have stopped being surprised by it and started being genuinely troubled by what it represents. Because what it represents is a federal judiciary being stocked, nominee by nominee, with people who cannot answer a four-word question about a presidential election. People who arrive with identical scripts and identical evasions and identical refusals to acknowledge documented facts. People who, if confirmed, will sit in courtrooms and ask other people to tell the truth, under oath, on the record, with consequences for failing to do so, while having demonstrated in their own confirmation hearings that telling the truth is something they are either unwilling or unable to do when the truth is inconvenient. Who won the 2020 election? 4 words, 1 answer. Kara Westerkamp could not say it, and Richard Blumenthal made sure the record reflects exactly that. Not with anger, not with theater, with the patient, relentless precision of someone who understands that what gets said in a Senate hearing room stays in the record long after the room has emptied, and what does not get said stays there too.